We, the people of India, have solely resolved the constitute India into a sovereign, socialist, secular, democratic republic to secure all citizens. Justice, social, economic, political, liberal of thought, liberal expression, or reverent belief, reverent faith and worship. Equality in status and equality in opportunity. Justice in social, justice in economic, justice in political. To promote among them all the fraternity assuring the dignity of the individual and the unity and integrity of nations. It is a Constitutional Assembly, the 26th day of November 1949, to hereby adopt the act and give to ourselves the Constitution. Note to the preamble. The preamble uses the word liberally of thoughts and expression is interpreted in articles of the court. It always said that the article is aid of objective and preamble, which is a former part of basic structure of constitution, because Article 19(1)(a) intuitively included the objective of the preamble and it's duty of the court to realize the value of the constitution. Devi Das Ramachandra Tuljapur is a state of Maharashtra, and there's many cases. The preamble is controlled constitution not framed by the parliament. Constitution is what the judges say, Supreme Court, advocates on record associates, the Union of India. It's well accepted by thinkers, philosophers, and academies that justice, liberal, equality, and fraternity, including social, economic, political, and justice, the golden goal set out by the preamble of the Constitution to be achieved by Indian politics, has been educated with excellence. We embark state of Maharashtra. The preamble of Constitution is framed with a great care and deliberate so that reflects the high purpose and noble objective of Constitution makers and Pradeep Jain Union of India. The task of legislation to arrive at the paragraphic balance between often competing interests of the personal liberty and the personal safety as by the Constitution, 40th sovereign democratic with respect to 3rd 1977. Some by the Constitution, 42nd Amendment, one provides the unity of nation. Abolition of caste system. It is an absolute imperative to abolish the caste system, and exponentially is possible for the smooth function of rule of law, democratic in our country, and state of Uttar Pradesh and Ram Sajjan. Independence of judiciary. It's the basic structure of constitution. Yes, be the president of India. The basic structure of constitution. The objective purpose are specified in the preamble contain the basic structure of constitution, which cannot be amended in exercising the power under section 368 of constitution. For theory of basic structure for the following judgment of the Supreme Court. Keshavananda Bharati Sri Padma Padgalvaru, State of Kerala, Indira Gandhi Nehru, Jai Narin, and Minara Wills Military Union of India, additional district magistrate Jabalpur, which is Sri Vakant Shukla. Which is the basic structure? The supremacy of constitution, republican democratic form of government, secular character of constitution, separate power between the legislation and execution and judiciary. The federal character of constitution is Kesavananda Bharati Sri Padma Galvaru, which is state of Kerala. Constitution philosophy. The approach of courts must be compatible with the constitution philosophy in which the director principle of the state policy constitutes the integral part. Harijit Singh, Punjab State of Warehouse Corporation. Duty of citizen. It is a constitution set up by every citizen who has a duty to obey the constitution, to respect the idea of constitution. Official liquidator of Jaya Dayananda. And federal structure. In Indian constitution is basically federal in form and marked with the traditional characters of federal system, namely supremacy of constitution, division of power between union and state government, existence of independent judiciary, and a rigid procedure for amendment of constitution. It is established of a dual politics within a clearly defined spheres of authority between union and states. It is exercised in the field of assigned to them respectively. There is an independent judiciary to determine issue between union and state to be exercised in the field assigned to be respectively. There is an independent judiciary to determine the issue between union and states. It is between one state and another. On amendment, it is respective jurisdiction of a union and state can be brought about only by invoking special provision in parliament and rectification by the majority of the states. However, there is a marked difference between American Federation, which is a classical federal model, and Indian Federation. First, in America, there is a dual citizenship, where India, there is only one citizenship. Indian citizen, whenever they reside, are equal in eye of law. And secondly, state of America have a right to make their own constitution. There is no such powers given in the states in India. Thirdly, Indian Constitution exhibits a centralized tendency of several provisions. That is, example, adoption of lengthy concurrent list and part of the parliament and reorganize the political structure of the country. The supremacy of parliament over the state legislation, if there is a direct conflict between the respective jurisdiction, vesting the residuary legislation power in the parliament, the power of government to reserve the bill and consideration of the parliament or the public. Further, in certain circumstances, the union is embound to supersede the authority of the state or exercise the power otherwise vested in the state. Fundamental law. The Constitution operates a fundamental law. The government own organs own their origin in the Constitution, derive the authority from, discharge a responsibility within the frame of Constitution. The Union Parliament, the state legislation is not a sovereign. The validity of law. Otherwise, the union of state is judged with reference to the respective jurisdiction and defined in the Constitution. The judiciary has the power to declare the law unconstitutional if the law is found to be contravention of any provision of the Constitution. Idealism. The idealism of secularism, socialism, democracy is elaborated by the enacted provision. See the underneath section. Bhim Singh G, Union of India, State of Kerala with V. and Thomas, official liquidator with Dayanand. About secularism, socialist right, Article 14 and 15 enable the court to deduce a fundamental right to equal pay of equal work and same board when right to the Article 14 enable the court to strike down the schedule which failed to achieve a socialistic goal to the fullest extent under means edition of the upon. Excelsior, Union of India, Atman Prasad, the State of Haryana, Ranveer Singh of Union of India, Das Nakhar, which is Union of India, Minerva Mills Limited, which is Union of India, Dharwad District PWD, Literate Daily Wage Employee Association Business, State of Karnataka. The interpretation of preamble. The preamble may be involved of determining the ambit of fundamental rights, directive principle of state policy, see and undermine the decision. Kesavananda Bharati, Sri Padma Kalvaru, State of Kerala, Chandra Bhavan, Boarding and Lodging, Bengaluru, State of Mysore, Dharwad District PWD, Literate Daily Wages Employees, Karnataka. The interpretation of statutes. The Constitution must be constructed in a wide, liberal mode so that the Constitution provision does not get fossilized but remain feasible enough to meet the newly emerging problems and challenges. M. Nagaraj, which is Union of India. The parent patron. The doctrine of the parent patron can be invoked a reason of sovereignty. The Charan Lal Shah, which is Union of India. And the power of Constitution power. The power must be derived from a specific provision of the Constitution. Synthesis Chemical Limited, which is Union of Uttar Pradesh. The preamble part of Constitution. Preamble is a part of Constitution. Kesavananda Bharati, Sri Padmagalu, which is State of Kerala. Constitution cost and responsibility of the state to suit the social, economic security of the preamble in the floodline, illuminating the path to one procedure of the state. Sovereign, socialism, secularity, democratic, public, a state of Jagannath, this Hari Yadav. Preamble of the basic structure. The objective specified in the preamble contain the basic structure of Constitution. Kesavananda Bharati, Sri Padmaguru, which is State of Kerala, Excelsior is Union of India. The preamble which therefore is a pressure to service to interpret the provisions like fundamental rights. Kesavananda Bharati, Sri Padmaguru, which is State of Kerala. Directive principle, Chandra Bhavan, which is State of Mysore. Res extra commercium. The doctrine of res extra commercium cannot be extended to prohibit the employee of a woman in a hotel and bar serving liquid. Anju Kang, Hotel Association of India. Secularism. The Constitution of India stands for secular state. That the state has no official religion. Secular provides which gives full opportunity for all persons to profess, practice, propagate religion in the choice. The Constitution not only guarantees the person freedom of religion and consent, but also ensure the freedom to one who has no religion, and it stipulates restraining the state from making any discrimination on ground of religion. A single citizen is assured to all the person irrespective of the religion. Dr. Radhakrishnan, former President of India, has a book of Recover of Faith, page 184, explains the secularism in the country follows. When India is to be secular state, it does not mean that we reject the reality of unseen spirit of relevant religion to life, or to be exiled irreligions. It does not mean that secularism itself become a positive religion or the state as assumed divine prerogative. He holds that no one religion is given a preferential status, the view of religious imparity and comprehensive forbearance, or a prospect to play a role with the national and international life. Constitution of India. Most important component of secularism are under Samananda incorporated Article 14, prohibiting any discrimination on the ground of religion, caste and incorporation of Article 14, 15, freedom of speech and expression, all the important freedom of the countries and conferred in the Article 1921. The right to practice religion conferred in the Article 25 to 28. The fundamental duty of the state to enable uniform civil law, treating all citizens equal to impose Article 14. Sentiment of majority of people towards a cow and against slaughter are incorporated in Article 48. See Besu, Constitution of Law of India. An eminent writer, Baishu, the Constitution of India 1988, he has described the expression secular in the war. He has often stated it would be a correct summary to provision. Article 25-30 says that the expression republic was qualified by expression secular, means a reputable republic in which equal the rest of all region. This is a proposal 40 of the Constitution bill which is passed by the Lok Sabha by default in Rajya Sabha because of the opposition of the Congress party. Secularism is a basic feature of Constitution. Yes, Sar Bhumi, Union of India. The concept of secularism put in the nutshell, the state dual has no religion. The Bal Puthul Union of India and social justice. Social justice enabled the core legislation to remove the economic inequality, to prove the decent or status standard of living to the working people, to protect the interests of the weaker section of society. See, understand section. Lingappa Pokshana Appeal War, which is state of Maharashtra. D.S. Naka, which is Union of India. Sadpuran Bansal, which is Pulling Bihari Shankar. The politics that turns a blind eye to deliberate inflection of misery on a large segment of population, even if it is the weakest form. And content cannot be condensed in view promise for the social, economic, political justice to citizens made by the Constitution of India. Nandini Sundar, state of Chhattisgarh. Socialistic concept. Democratic secularism aims to end the poverty, end the ignorance, end the disease, and the inequality of opportunity. The socialistic concept is ought to be implemented the true spirit of Constitution. J.P. Pandit University of Agriculture Technology, State of Uttar Pradesh. Sovereign. The word sovereign means the state has power to legislate on the subject of conformity with Constitution limitation. Synthetic or chemical limited, State of Uttar Pradesh. Constitution of India. Being a sovereign state, India is free from any type of external control. It is acquire foreign territory if necessary, core part of territory in favor of foreign state, and subject to certain constitutional requirement. Maganbhai Ishwarabai Patel, which is Union of India. Structure source of Constitution. A source of Indian Constitution can be best explained with reference to a principal part. The structural part of Constitution is to large extent derived from the Government of India 1935. The philosophical part of Constitution has been other sources. Part 3 of fundamental rights, partly inspired by the Bill of Rights, enshrine the American Constitution. So part 4 of the directive principle of state policy from the Irish Constitution. The political party, the principle of cabinet government, its releases between the executive and legislation has been largely joined in the British experience. The union, state, religion relationship find the similarity in the Act of 1935, also Canadian Constitution, through the expanding the concurrent list of the 7th schedule, a model of Australian Constitution. The Part 8 deals with the trade, commerce, intercourse, also appears derived, inspiring from Australian Constitution. Some indigenous institutions like Panchayat has been specifically encouraged a new idea such as promotion of international peace and security has been woven in the fabric of Constitution. This Constitution specifically provides a privilege of the members of the Parliament and of state legislation to some extent of following Australian model. Structure of government and fundamental aspect of Constitution. The Indian Constitution, adopted by the Constitution Assembly of November 26, 1948, is a comprehensive document containing 395 articles and several schedules. Besides dealing with the structure of the government, the Constitution makes a detailed provision for the right of the citizen and other person in the number of entrenched provision for the principle followed by the state and the governments of the country, labeling directive principle as state policy. Historical, geographical factors has been responsible for the build of this Constitution. It's the largest Constitution of the world. Framers of the Constitution were keen in observing the democratic values of the Indians were attached the highest importance in the struggle for freedom. But they were also being keen to make provision considering it necessary in the light of social, economic burdenness of certain section of society. They have also been in the President's of Government of India Act 1935, whose detailed provision were found suitable for adaptation respect of the continuity and certainty. Some precaution from the constitution image has been distorted, being impaired, and as essential features were also be required. All this considered to be length of Indian constitution. Union nations. The preamble declares India to be a sovereign. The preamble declares India to be sovereign, socialist, secular, democratic republic. It is declared the constitution has been given by the people to themselves, thereby affirming the republic character of the polity and sovereignty of the people. Democratic character of Indian politics is illustrated by the provision conferred on the adult citizen and a right to vote and the provision to elect a representative responsible for the execution to the legislation. Corruption. The corruption is opposed to democracy and social order. It is not only anti-people but also destroys national culture heritage. It is poses a threat to the concept of constitutional governance. It shakes the very foundation of democracy and rule of law. It threatens the security of the security. It threatens the security of the society, undermining the ethical value and justice, jeopardizing the substantial development. The corruption devolves the human rights. State of Gujarat to Aram Mehta. Part 1. The Union of Territory. Yes, the name Union Territory. India, the Bharat shall be India, that is Bharat, shall be Union of States. The state and the territory therein shall be specified in the first schedule. The territory of India comprises territory of the state, union territory specified in the first schedule, and such other territories may be acquired. Article 1. Union of India. The article constitutes India as a union of states, thereby implying an indestructible nature of unity. No unit constitution of Indian Union or a seconded from it. The Constitution Assembly debates 43. The country is divided into several units because of the states and union territory, and Constitution laid down only the structure of union government but also the structure of the state government. Union of India is a federal union, which is a dispersion of distribution of power of which judiciary is interpreted. Although there may be a considerable controversy whether India is or not a federation, although same writer is called and perceived federal, and seen that the essential of Indian Constitution on the federal rule. Special reference to 195. Acquisition of foreign trade. Acquisition of foreign trade territory does not fall to the Article 1 of international law. Joe, Dash, Shasta, and Bosha, Sadda, Shiva, Sinai, Norcosin. Article 1 does not confer the power of acquire foreign territory in a Beruba union of exchange of enclaves and enclaves. Action of subsequent to acquisition. The foreign territories which is being part of Indian acquisition either be admitted into the union or constituted into a new state. Article 2. Merge in the existing state on Article 3A, 3B, formed in the union territory. Of course, a foreign territory could not be come under the article until the legal transfer of territory to India. So, the constitution acquisition of acquisition in international law, see the undermined sections. Hari Vance with the state of Maharashtra. N. Mastan Sahib is Chief Commissioner Pondicherry. Thakur Amir Singh Ji, state of Rajasthan. The permanent resident of Jammu and Kashmir. The permanent resident of Jammu and Kashmir are citizen of India, State Bank of India, and Santosh Gupta. The borders of state. The territory, state, or the component of constitution was not frozen, and the constitution provided for the prospective change, including alteration of the borders. Ram Badan Ravi, Union of India. Law applicable to acquiring territory. On acquisition of a territory, a pre-acquisition of law and a right acquisition therein may continue only. It is new generation chooses to recognize them unequally. Vinod Kumar Shankila Goshila versus Gangadhar Narasingh Karna. Meaning of the territory of India. The meaning territory of India is used in several articles of constitution, and in every article where the phraseology is employed means territory of India. The time being on fall into the article, but a space cannot be meant different territory and different article. Mastan Sahib and the Chief Commissioner Pondicherry. Territory water, section 32 of territory water, constitution shelf, an exclusive economic zone, other maritime zones. Provided the limit of the territory water is in line, every point which is a distance of 12 nautical mile from the nearest point of appropriate baseline. Another notification of the government dated on 15th January 1970 extended the exclusive economic zone up to 200 nautical mile into the sea from the shore baseline. It is being done for territory water, constitution shelf, exclusive economic zone, and other maritime act 1976. Be passed on the Constitution 40 Act 1976, Territory of India. The expression Territory of India, wherever use a name or territory which at the time be fall within the Article 13, see the undermined decisions. Thakur Amar Singh Ji, State of Rajasthan, M. Mastan Sahib versus Chief Commissioner Pondicherry. Admission establishment new state. Parliament may by law admit into union establishment new state on such items, terms and conditions things fit. Note to Article 2. Admission of new state. The power to admit new states into the union and Article 2 is no doubt is the very nature of the power and very wide is exercising necessary to guide the political issue of considerable complexity and many of which is not judicially measurable. R.C. Paudgal, Union of India. Formation of new state. The power in which Parliament is vested in Article 2 provides an admit, establish a new state which confirm the democratic pattern and legacy of constitutional power which Parliament is exercised under the Article 14 a supplement and incidental consequential to the admission, establishment, forming a state, contempt of the Constitution. Formation of a new state, altering of area boundaries now existing. Parliament by way law. Form a new state by separating territory from any state of being union or two or more state, a part of states as a union or a territory part of state, increasing area of a state, diminishing area of a state, altering the border of the state, alter the name of state. Provided no bill for the purpose shall be introduced in either House of Parliament except on recommendation of the President unless where the proposal contains a bill affect the area, boundaries and name of any of the states. The bill has been referred by the Parliament of Legislation and State or expressing a view therefore which is the period by which specified reference and within such further period of the President may allow the period so specific. Allow me to explain. In this article, the state includes union territory, but the provision state does not include union territory. The power conferred in the Parliament by the Clause A includes power from new state and union or united parts of state, a union territory or another state or union territory. Agreement between India and Bangladesh. The lease agreement is an perpetuity to some area of Bihar, Indian territory, to Bangladesh. It did not amount to lease on surrender of sovereignty. It's amount to servitude suffering suffered by India. Union of India, Shukumar Singh Gupta. Now, the effect of reorganization of the territory under the existing laws. The principal relation to exchange sovereignty in international laws are not applicable to the reorganization of territory, the state of Article 3. When such adjustment or reorganization of territory takes place, the existing laws as well as administration order in the particular territory continue to be enforced and continue to be binding as successor state. As long as they are modified, changes and reputable to the successor state, the undermined decision, state of Panchayat and Bhaidid. Interstate agreement of water. The state cannot claim to have legislative power over the right of receive or utilize the water. Mullai Periyar Environmental Protection Forum, Union of India. Reference to Central Bill of States. Once the original bill is referred to states or the states that pursue the provision served, no fresh reference to require every time an amendment of bills moved to accept according to the rules of procedure of Parliament. Parliament is not bound to accept or act upon the view of state legislation. Even this view of receiving time. Bahubal is a state of Bombay Air. Substitution of the Constitution of the Constitution, Section 1955, Section 2 provision on December 24, 1955. The words of the letter specified the Part A and Part B of the schedule permitted by the Constitution of the Act of 1956, Section 29, with respect to November 1, 1956. Instead of the Constitution of 1966, with reference to August 27, 1966.